May it please the Court. My name is Adam Steele. I am the counsel representing the petitioner, in this case, Ms. Pamela Seitz. Our case centers on the intentional infliction of emotional distress or outrage surrounding the unprofessional and unacceptable conduct of the staff of Humana Hospital towards Ms. Seitz when she was a patient there in 1985. At that time of her life, she was a patient, like I mentioned, and was at an extremely vulnerable point. We are therefore respectfully asking this court to reverse the original summary judgment and remand the case for full jury trial. The original trial, the court committed the following errors. First, there was the improper application of standards of professional responsibility and patient vulnerability according to the Restatement of Torts, Comment F. The conduct of the hospital staff in this case was legally outrageous. The trial court usurped the role of the jury in this case, issuing a summary judgment based on the disputed issue of the systemic recklessness of the hospital and its staff in this case. Seitz, as I mentioned, was admitted to Humana Hospital in 1985, suffering a ruptured membrane and also being pregnant. This is a deadly condition for both the mother and her unborn child. Near constant monitoring is required in order to ensure both safety. Despite this, there were several systemic failures that would ultimately occur, leading to the loss of Seitz's unborn child. At the onset of labor for Seitz, both her as well as her roommate attempted to call for help. Both of the nurse call units in this case would fail. Her roommate would yell down the hall for help, and a cleaning staff member responded, not a medical professional. Nurses in this case were delayed by between 12 and 15 minutes. The failed call system combined with a delay in response time of nurses highlights the severity of the breakdown of the hospital's emergency procedures. Also calls into question whether the hospital was appropriately staffed to care for its patient population. The nurses in this case were noted to have told Ms. Seitz, and I quote, "shut up," while they were dealing with the emergency. One also made a comment noting that fetal remains would be disposed of on site. Both of these actions violate the ANA Professional Code of Ethics, Section 1.1, wherein it is noted that patients must be treated with dignity and respect, especially in a crisis. Seitz's physician would ultimately come to testify to the lack of compassionate care in this case that was provided to Seitz by the nursing team. There was also a great deal of avoidable emotional harm that was ultimately caused. In this case, it was noted that there was a severe and inexcusable pattern of systemic failure on the part of Humana. There was the mechanical failure, the delayed response, as well as the inappropriate decorum shown by the nurses in this case. All of these indicated a severe breakdown of hospital safeguards at an extremely vulnerable point in my client's life. With that, please allow me to turn to my first argument, the legal error at the trial court level. The trial court failed to apply the lower standard for outrageous conduct, which is mandated in the Restatement of Torts, Section 46, Comment F. When a hospital is caring for a patient with a documented high-risk condition and has actual knowledge of that patient's susceptibility to emotional distress, the threshold for outrageous and intolerable in a civilized community is lowered significantly. This court affirmed this in controlling precedent Kraft versus Rice. The facts of this case meet the lower standard. Seitz was admitted in this case suffering from a ruptured membrane and also being pregnant at the time. Hospital records and observation show actual knowledge of Seitz's condition and vulnerability. The court therefore must apply the lowest standard under Comment F. Despite the previously mentioned knowledge, conduct by staff indicates recklessness as well as a systemic violation of professional ethics during an obstetric emergency. There's the 12 to 15 minute delay in response time due to system failure, as well as the trauma suffered by Seitz that was compounded. Emphasis on the previous shut up comment, as well as the comments made regarding the disposal of fetal remains at the hospital, both being violations of the ANA Code of Ethics, Section 1.1. Seitz's physician, as mentioned previously, testified to the lack of compassion shown by nurses in this case, as well as the emotional trauma suffered by Seitz that was wholly avoidable. When analyzed under the correct standard, the conduct of the staff, the systemic failure, as well as the verbal abuse, all constitute conduct which is legally considered to be outrageous. The trial court erred by rendering a summary judgment in this case. We are therefore asking that this court reverse this previous ruling. Regardless of if this court upholds the initial trial court's ruling regarding outrageous conduct or reverses the previous judgment, reversal is required regardless. This is because there is a factual dispute, and the only trier of fact in a trial is the jury. They must be allowed to hear and deliberate on systemic recklessness that is present in this case. The jury is the trier of fact. In a summary judgment, a court must view all evidence presented and any inferences that might be present in a light that it favors the non-moving party. In this case, that is my client, Ms. Seitz. Any slight issue, no matter how slight, regarding material fact mandates a jury trial. In this case, the hospital did not provide any logs regarding staffing or maintenance regarding its nurse call system, nor did it provide audit reports of these logs. The absence of these logs creates a genuine factual dispute that only a jury is permitted to resolve. The jury may draw negative inferences against Humana for not providing these records under controlling Kentucky precedent Sanborn versus Commonwealth. Possible inferences may include chronic understaffing as well as a willful neglect of a life safety system, that being the nurse call system. Both are crucial for proving recklessness. At trial, initially, the judge failed to properly render summary judgment. Seitz was denied the benefit that Sanborn could have provided her. The trial court improperly resolved a disputed fact in this case, thereby usurping the role that would normally have been filled in this case by the jury. We therefore ask this jury to reverse and remand this case for jury trial. May it please the court. Your Honors, evidence presented here today shows the presence of two critical reversible errors in the trial court's summary judgment. The first being legal error. The court failed to properly apply the legal standard from the Restatement of Torts, Comment F. The misconduct of nurses, delayed response times, as well as comments made to Ms. Seitz of shut up and regarding the hospital's disposal of fetal remains were dismissed initially as negligence. However, given professional duty and actual knowledge on the hospital's part of Seitz's condition, as well as extreme vulnerability, the actions of the hospital and its staff are outrageous. This was confirmed in testimony given by Seitz's physician regarding avoidable emotional trauma that she suffered. 2. In the initial trial, the court usurped the jury's role as fact finder. The judge denied the Seitz her right to negative inference that would have otherwise benefited her under the Sanborn precedent. This negative inference stemming from the hospital's failure to provide maintenance logs, staffing logs, as well as their associated audit reports. Recklessness, in this case, remains a material and disputed fact. Based on the trial court's decision to utilize flawed logic in its decision surrounding outrage, as well as the denial of Ms. Seitz's right for jury to deliberate the systemic recklessness issue here, we are asking this court reverse the previous summary judgment and remand the case for full jury trial. Thank you. We respectfully submit this matter.